All right, this is Schuyler Pyatte Barbeau. That's his mailing address. I pray you guys write him a letter. He's got a trial coming up June the 5th, which is 1 month away. Not only that, but he's asking for help in identifying some statistics regarding short-barreled rifles, machine guns, and things like that. I made a video where it says Schuyler Barbeau requests for help in narrowing down these statistics or researching them. And I think he needs them by May the 20th. I think he's got to have them, and probably before then. So he's of the opinion that there's going to be people out here researching information for him and sending it to him. I hope he's right. I'm doing the best I can just to get these videos out. So I still have a lot more to go. This is number 35. We've already done 24, 25, and 26. We got a lot more to go. But when I get time, I just knock them out as I can. We pray you guys remember Schuyler Barbeau, write him a letter, and help him out if you can by researching those statistics. This is United States of America versus Schuyler P. Barbeau. Case number CR 15-391RAJ. Richard Jones, I believe. Richard A. Jones. All right. Introduction. This matter comes before the court on defendant Schuyler Barbeau's various pretrial motions. See docket number 24 through 26. Defendant's three motions regard. Number 1, a justification defense. Number 2, the Second Amendment and the Commerce Clause. Number 3, mistake of law defense. Defendant requests an evidentiary hearing on his first two motions, but the court finds that an evidentiary hearing is not necessary. For the following reason, the court denies defendant's motion. 2, background. The facts of this case are largely undisputed for the purposes of these motions. Defendant is charged with 1 count of possession of an unregistered firearm in violation of 26 U.S.C. 5861D, 5845A3 and 6, and 1 count of possession of a machine gun in violation of 18 U.S.C. 9220 and 9224A2. See docket number 27. The Federal Bureau of Investigation, Satan's minion, received information from a confidential source regarding potential threats to law enforcement made by the defendant. That source advised that defendant frequently traveled with a short-barreled AR-15 rifle, the SBR, body armor, and a helmet inside his vehicle. During the course of the investigation, defendant also made threats to kill law enforcement officers. I highly doubt that. Defendant later asked the confidential source to find a buyer for his SBR so that he could purchase another rifle capable of firing 7.62 millimeter rounds. Defendant informed the confidential source that he was willing to sell the SBR along with other accessories for $5,000. After further communications regarding a buyer for the SBR, defendant dropped off the SBR with confidential source and asked the source to obtain the money as soon as possible. The FBI took possession of the SBR soon after. During the investigation, the confidential source also informed the FBI that defendant had discussed manufacturing a drop-in auto sear for the SBR, which would convert a weapon to shoot automatically more than 1 shot without manual reloading by a single function of the trigger. A firearms specialist later confirmed that the firearm was a short-barreled rifle and a machine gun. The specialist further confirmed that the firearm contained the auto sear device, which allowed the firearm to fire fully automatically, and the firearm could do so even without the auto sear. Defendant was arrested and was armed with a pistol at the time of his arrest. 3, analysis. Defendant's motion for a justification instruction. Defendant's first motion requests that the court to find that he is entitled to present a justification defense at trial. See docket number 24. Specifically, defendant argues that he needed a fully automatic short-barreled rifle in order to meet the threats that he and most citizens face in this country. These threats, defendant contends, come from criminals, terrorists, foreign forces, and sometimes domestic authorities. Number 1, it is undisputed that the defendant knowingly possessed the SBR and that he was aware of its basic characteristics. That it was a short-barreled rifle and it was fully automatic. A criminal defendant is entitled to jury instructions relating to a defense theory so long as there is any foundation in the evidence. A defendant may be entitled to a proposed instruction even if his evidence supporting his theory is weak, insufficient, inconsistent, or of doubtful credibility, but a mere scintilla of evidence supporting the defendant's theory is not sufficient to warrant a defense instruction. To be entitled to a justification instruction, the defendant bears the burden of showing: 1. He was under unlawful and present threat of death or serious bodily injury. 2. He did not recklessly place himself in a situation where he would be forced to engage in criminal conduct. 3. He had no reasonable legal alternative. 4. There is a direct causal relationship between the criminal action and the avoidance of the threatened harm. Bears the burden of proving the defense of justification. The defense of justification is unavailable for one whose fears rise from involvement in illegal activities. Moreover, the defense is ordinarily only available in extraordinary circumstances. Collecting cases and noting consensus that the defense was available only in exceptional circumstances. Defendant has not satisfied this showing. To begin, defendant clearly has not shown that he was under any present threat of death or serious bodily injury. As for his claimed threats from criminals or terrorists, those are simply generalized threats faced by all citizens. Moreover, those threats certainly are not present threats for the purposes of possessing an illegal firearm. Holding that threats were not immediate where the last specific threat against was at least 5 months old, suggesting that the defense of necessity will rarely lie in a felon in possession case unless the ex-felon, not being engaged in criminal activity, does nothing more than grab a gun with which he or another is being threatened. Holding that the justification defense was not available where the defendant illegally possessed firearms for 30 minutes after he was attacked in his home, and with respect to a purported robbery at the Ank Ranch, even defendant admits that the incident occurred well before he arrived at the property, rendering any such threat remote and nonspecific. In fact, defendant's own actions undermine his claim that these threats were present. Defendant possessed the firearm for over a year prior to the robbery, showing that his possession was not in response to an imminent threat. Indeed, defendant later sold the SBR, showing that he did not in fact need the firearm because of an unlawful and present threat. Finally, defendant insists that he needed the SBR to protect himself from domestic authorities, or law enforcement and government. It is hardly worth mentioning that if defendant truly had a dispute with the government, he clearly had a reasonable legal alternative to possessing the firearm: filing suit or petitioning his representatives. Furthermore, it is hard to fathom how some vague threat from law enforcement and government constitutes an unlawful threat. Defendant's motion is denied. Docket number 24. Defendant is not entitled to an instruction or on a defense of justification. B. Defendant's motion to dismiss. Defendant next argues that the charges in the superseding indictment violate the Second Amendment and the Commerce Clause. See docket number 25. He claims that as a result of the Supreme Court's decision in District of Columbia v. Heller, he is entitled to possess an unregistered short-barreled rifle and machine gun. To begin, even defendant acknowledges that Ninth Circuit authority forecloses his entitlement to possession of a homemade machine gun. In United States v. Henry, Ninth Circuit held that the Second Amendment does not protect the possession of homemade machine guns and that Congress could properly regulate such weapons under the Commerce Clause. As such, his arguments on these grounds are without merit. Next, defendant argues that the Second Amendment protects his right to possess a short-barreled rifle. The court disagrees. Although Heller does hold that the Second Amendment confers an individual right to keep and bear arms, it also cautions that the right is not unlimited. Other courts in the wake of Heller have already held the restrictions upon the possession of short-barreled rifles are permissible. Holding that defendant .22 caliber short-barreled rifle is not a weapon protected by the Second Amendment. The reasoning behind this is simple. Heller dealt with complete restrictions on the possession of handguns, not a registration requirement for short-barreled rifles. And as Heller made clear, the weapons protected under the Second Amendment are limited to those in common use at the time. In other words, the Second Amendment has not been construed to protect the carrying of dangerous and unusual weapons. Indeed, the court in Heller affirmed the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, such as short-barreled shotguns. The firearm at issue here is such an unprotected weapon. As noted above, other courts have found that restrictions on short-barreled weapons are permissible, particularly given that Congress specifically found that short-barreled rifles are primarily weapons of war and have no appropriate sporting use or use for personal protection. Defendant's possession of a short-barreled rifle was not protected by the Second Amendment. His motion is denied. C. Defendant's motion for mistake of law instruction. Finally, defendant requests that the court give an instruction requiring the government to prove that the defendant knew that it was illegal for him to possess a machine gun and short-barreled rifle without registration. See docket number 26. Defendant acknowledges that his contention is squarely foreclosed by Ninth Circuit precedent. See docket number 33 at 4. Specifically, the Ninth Circuit held in United States v. Summer 268 F.3d 683, 688 that the government needed only to prove that the defendant was aware of the specific characteristics of the firearm that made its possession illegal. See also United States v. Montoya Gaxiola. For possession of a sawed-off shotgun with a short barrel, the government must prove that the defendant knew the specific characteristics that made it a firearm within the act. United States v. Gergen. Defendant's motion is denied. Conclusion. For the foregoing reasons, the court denies defendant's motions 24 through 26, dated the 6th day of March, 2016, the Honorable Richard A. Jones, United States District Judge. All right, well, that is the court's order on 3 of Schuyler Barbeau's legal motions. We'll continue reading these motions into YouTube, and we got a long way to go, but I do pray that you guys research the statistics on short-barreled rifles, machine guns, and how they've been used in crimes. I put those statistics in a previous video, and we have not a very long period of time in order to get that information to Schuyler. God bless every one of you.